This case is Deal versus Hamilton County Board of Education, which was decided in the U.S. Court of Appeals, Sixth Circuit, number 03-5396. It was decided on December 16th of 2004. This case is about the rights of parents and children under the Americans with Disability Acts and IDEA. The facts of this court case are this. Zachary Deal was a child who was diagnosed on the autism spectrum. In my research, I did not see where on the spectrum he was or any more specifics other than that he had autism. These parents disagreed with the IEP proposed by the school, and they sued for reimbursement of both private school placement and the cost of an alternative method of autism treatment. And when I say alternative, I don't mean like acupuncture or herbs. They actually had a treatment plan called Applied Behavior Analysis that had been developed by a professor at USC and showed a very good success rate. And that was the whole basis of this whole court case was the ABA. The Deals wanted the school to pay for ABA, and they steadfastly refused any other educational plans. The school steadfastly refused to provide this service. Does the school have this right? In the original case, the judge ruled that the school acted inappropriately by refusing to deliver this service. He used some very strong language about that as well. The parents pretty much were saying, we want Zachary to receive ABA instruction. He is making tremendous progress. The school, it is not part of our plan. We cannot afford to pay for it. The court in the first court case expressly held that Hamilton County's autism consultant, Ann Kennedy, was not credible and showed an appalling lack of knowledge. That was a quote I thought showed just how high tempers got in this. So the history is this. In 1999, the Deals requested an administrative hearing because they felt like they were making no progress with the school district. Who would not even consider giving him the ABA treatment. In 2001, the administrative judge, Andrews, he ruled in favor of the Deals. He said that the school had behaved appallingly, and he ordered them to be reimbursed for both the ABA treatment that they were giving him, as well as the private school that they eventually enrolled him in. Of course, the school district appealed. And in 2003, the district court overturned some parts of the decision. The judge in 2001, Judge Andrews, had said that there were terrible violations of IDEA and that the Deals were entitled to a lot of money. In 2003, the district court said that there were some violations, but IDEA was not part of it. And so they reversed most of it, including they said that they didn't get any money, but that there had been violations. It was appealed again. And in 2004, it went to the circuit court level where they had even more testimony taken. And they eventually ruled that there were no IDEA violations and that the Deals were not entitled to any money. But they did stand to the fact that the school had not behaved appropriately at all times. This case took 7 years to resolve. Zachary was a 3-year-old when this started, and he was a 10-year-old when we had our final decision. Over $300,000 was paid in legal fees by the school district, and it took 3 trials to come to a final conclusion. What did we learn from this? The first thing I'm going to say is make sure that all procedures are observed. There were some really inappropriate comments made in the testimony. The head of the special education department is quoted as saying, if people would just pay their taxes, then they could give Zachary ABA. She also told the parents that the school was not going to pay for it. They could not afford the cost of it. And in one of the IEP meetings, she actually told the parents that they could not ask questions. These are things that, no person in there, no reasonable person should be saying, especially in front of not only witnesses, but the parents of the child who is being the subject of these meetings. I think schools should provide training in conducting IEP meetings. I have been to many, many, many in many districts. Well, not many districts, but 3 different districts. And I have never had any training on what goes in an IEP meeting. Very often I am asked to sit in as the regular education teacher in meetings. And while I have no problem with helping out, and I understand the tremendous amount of work that is put in by our SPED teachers and how hard it is to schedule meetings at times that everyone can be there, if you're going to have people in these meetings, you need to make sure that they understand what the process is and what's going on. I think that administration needs, not just the special education people, but administration needs to stay abreast of education research. There is breakthroughs, there's things going on all the time. ABA is a well-researched, well-documented form of treatment for autism, and it wasn't even considered by the school. It actually cost the school much more to defend itself than it would have just to give Zachary the program. So that might be putting a cart before the horse thing there, where they just, cut off your nose to spite your face. What I learned on this, and what I have learned over the course of my education career, is that parents of students who have IEPs are most often the parents who know the most about what it entails, and they are oftentimes the most forceful about standing up for the rights of their children, and that no one should be dismissing these kind of things, and no one should be putting themselves in a situation where it has to go to 3 different trials just to get the student what he needs. This did not make the Hamilton County School District look good at all. Even though eventually they won, they certainly didn't look like they had their act together. So as an administrator, I know that if I don't know a question or I am not sure about what policies or procedures we're doing, I am definitely going to ask questions. I'm going to make sure I know what I'm doing. And so that is our summation for Deal versus the Hamilton County Board of Education.